In a sigh of relief to students who were arrested or detained following the Sansad Chalo protest in Delhi and other states, the Supreme Court on Tuesday directed the police to immediately release them. However, the court says that these students should not have any criminal antecedents. Besides Delhi, the other 7 states are Bihar, Uttar Pradesh, Maharashtra, Madhya Pradesh, Assam, West Bengal and Kerala. The order is part of significant interim directions that were issued by the top court on Tuesday. A 3-judges bench led by Chief Justice Suryakant passed the order in response to a batch of petitions filed by protesters, including some injured victims, demanding a fair probe into the use of excessive force by the police and fixing accountability. These protests, as we know, were triggered by the NEET paper leak this year and saw participation of thousands of students from different backgrounds. In its order, the court also took care of the concerns raised by the protesters on the possibility of destruction of police data and evidence. It directed preservation of CCTV footage, drone footage, body-worn camera recordings, wireless communication and PCR logs for the days when the protests were happening. It even refrained the police agencies from releasing or publicly sharing, for now, data and personal information of student protesters gathered during the protests. As the bench proposed a probe committee to be headed by a former Chief Justice of India to address the grievances raised by the protesters, families of police personnel who were injured during the 20th July violence, as well as the concerns raised by the centre, it allowed the Delhi police to continue with investigation but prohibited from taking any coercive action against any student. It also gave liberty to the police to withdraw any case. However, for those with criminal background and found to be antisocial, the bench gave a go-ahead to the police to continue with their probe. After recording the arguments advanced by the petitioners, family members of injured policemen, and centre and Delhi government, the bench observed in its order, and I quote, "The allegations made by the petitioner prima facie make out a case of an independent fair probe into the incidents of violence. Such probe will effectively address the allegations made by the police personnel and the concerns raised by the Solicitor General of India." However, the court did not want to pass an order on the basis of a tentative opinion and deemed it appropriate to seek a formal response from the centre and Delhi government to the allegations levelled in the petitions. It therefore issued notices to the Union of India and Delhi government. It even asked chief secretaries of the 7 states to make an appearance on 3rd August, which is the next date of hearing in the matter. These officers can be represented through a council. During the hearing on Tuesday, the court agreed with all the petitioners that the instances brought to its notice required an independent probe, law must take its own course, and responsibility must be fixed. A battery of senior lawyers appearing for the injured protesters placed on record a multitude of instances alleging indiscriminate and excessive use of force by the police. This included use of pellet guns, lathi charge and tear gas. The violence counsel alleged was perpetrated by police personnel in civilian dress. Those in uniform failed to follow the guidelines laid down through various Supreme Court judgments. It was also pointed out that there was no prohibitory order on July 20th at the spot. The court also heard the counsel who appeared for the family members of injured cops. They claimed that many antisocial elements had joined the protest and attacked the policemen deployed there and injured them seriously. Both sides submitted to the court photos, pen drives of the violence. Meanwhile, Solicitor General of India Tushar Mehta, appearing for the centre and Delhi government, said he had no objection against a fair probe as suggested by the court. He, however, refuted any police excesses and submitted that hardened criminals and undesirable elements at the protest site had indulged in violence. The solicitor pointed out that more than 200 police personnel had suffered serious injuries. He, however, did not deny that the attack on students was a serious matter and the government cannot take it lightly. The petitioners then demanded preservation of logbooks maintained at police stations, the general diary kept by the police, and records to show who requisitioned the arms and ammunition on the day of the Sansad Chalo protest. An appeal was also made to the court to ask Delhi police to allow e-registration of complaints by students who were attacked on 20th July at Jantar Mantar. The court was informed that the Delhi police portal allows e-registration of offences related to theft. Opening of an e-registration will enable the students to register their cases online instead of going to the police station physically to do the same. During the hearing, the bench also made oral remarks about the lack of adequate protective gear for the police personnel who were posted at the site on the protest day. Protective gear is more important than the offensive gear, the bench remarked. At this, the petitioners' counsel clarified that they were not against the entire team of police, saying it was not a finger-pointing exercise. What they were aggrieved of was the non-action by the police against those who were not in uniform and assaulted the students. The bench was also told that the police had collected data on students through the facial recognition system that was deployed at the site. The said data has been collated with Aadhaar to identify the students who are now receiving notices from the Delhi police to appear and record statements.